Good morning, everyone.
Good morning, sir.
Morning, sir.
Today we'll be taking up the last slide because there was one topic that was could not be discussed last time, and this is the last point in the last slide, that is not expressly declared void. Last time we had taken up the essential elements of a valid contract. In any contract, these elements, they have to be there. If there's, these elements are not present, then the the contract will not be valid, and it would be void. And sometimes when an agreement is entered into between two parties, it is void from the very beginning, from the very start, because any of these elements, if they are not present, would lead it to become void, and it cannot become a contract. So the last point we could not discuss because the time for the slot was not there, and so we'll take up the last point. Any of the earlier points, if there's any problem with any of the earlier points, particularly in understanding those terms, or perhaps we can discuss those. Any problem with the earlier terms, earlier elements, those offer and acceptance, intention, lawful consideration, all these points?
Sir, could you please repeat the capacity of parties?
Capacity of party, okay. Capacity of party means that if a particular party does not have the capacity, basically capacity means that if a particular person is minor, for example, less than 18 years of age, a person who is minor does not have the capacity to reasonably undertake a contract. That means understand the obligations under the contract, or the rights of the party under the contract. So a person, if any person or any party which is not capable of reasonably understanding the terms and conditions laid down in the contract, that then that contract would not be valid. Likewise, if a person is having, say, serious fever, for example, so during the reasonably, and will not be able to contract. Likewise, if a person by birth is having idiocy, then naturally the brain is not well developed and does not have the capacity to sign the contract. Likewise, a person who is under hypnotism does not have the capacity to think reasonably, and likewise, a person who is drunken, for example, he loses that capacity to think reasonably. And under such conditions, under all these conditions, the person, if he enters into an agreement, that agreement will be void and cannot become a contract, because the person does not have the capacity to think reasonably the terms and conditions, the obligations, and under the contract, and does not understand his own rights under the contract. So in such cases, the party does not have the capacity to sign the contract or enter into a contract with other parties.
Thank you, sir.
Sir, is it necessary that a contract should be in written form?
No. It's not necessary that the contract should be in written form. A contract can be, say, by spoken words even, um, and a contract can be formed by the conduct of the parties. That means not verbally, but by the conduct it's also. I'll give you the examples of how these the conduct. For example, if you take a bus or board a bus to say Noida, I gave this example earlier also. There's no written word or which is made or any statement made, or even if you do not speak a single word, you just sit on the bus and the bus starts. You enter into a contract with the transport company and you're bound to pay the price of the ticket from say Aligarh to Noida. So by the conduct of the parties, even the contract is made. Likewise, if you enter a restaurant and you start eating the food which is delivered to you, or you enter into a contract. Likewise, if someone say, for example, if you go to a railway station and the coolie, who is in uniform, takes up your luggage and starts, taking your luggage outside the station, and you allow him to take that luggage, you're bound to pay the fees of that porter.
So then
So-
what is the meaning of this point, writing and registration?
Writing it. There are certain contracts which need to be in writing. There are certain. I mean, all contracts, they are not required to be in writing, but there are certain contracts which have to be in writing. For example, the lease of land, for example, or the sale of land. So sale deed has to be in writing and it should be registered. So there are certain types of contracts which need to be in writing. But all contracts, they need not be in writing. And then when registration is done, naturally the requisite number or the requisite say amount of the stamps have to be affixed. If they are less than the amount that's required, the registration would not be made, and so that that particular contract would not be valid. Yes, anything else? So we'll take up the last point, not expressly declared void.
Sir, possibility of performance. What is possibility of performance?
Possibility of performance, that it should not be very, impossible. Like, for example, you have heard of the name of Virgin Airways owner. What's his name? Richard Branson. Okay. So Richard Branson, he intends to take tourists to moon, for example. Probably he may make it, but if suppose Richard Branson promises the tourists to take the tourists to say Mars, for example, so that particular, and takes an advance from the tourists, I mean, that particular agreement would not be valid because it's not possible. At least for the present, it's not possible. So any such promise that is made by any party, which is not possible, which is impossible, would not translate into a contract, would not be enforceable in the court of law. So the other party should not believe of such a promise, and naturally that promise cannot be valid. This particular agreement would not be valid. It would be void ab initio, that is void from the very beginning. Yes, anyone else? So I'll take the last point, which we could not take last time. That is not expressly declared void. There are certain agreements which are expressly declared void. For example, an agreement in restraint of marriage. Now, it's a right for every human being to enter into marriage relations. Any agreement that is made by two parties or more than two parties not to let any person marry or inhibit a person to marry, that would Abdul Ahad, please mute your mic. Abdul Ahad, okay. So any agreement that is made to restrain the marriage, that would be void from the very beginning, void ab initio. Likewise, any agreement that is entered between two parties in restraint of trade. Trade is a legal right of any, say, citizen and should not be suppressed. So everyone has a right to trade as long as the trade is lawful. So as long as the trade is lawful, every person has the right to trade. And in case if there's an agreement to restrain the trade, that agreement would be void. Likewise, any agreement in restraint of legal proceedings. Legal proceedings, everyone has, any organization or any person, natural person has the right to undertake legal proceedings in case, suppose a person's or institution's rights, they are not say observed by the other party. So an agreement which is made that a particular party will not approach the institutions for redressal of the grievances, would be, that agreement would be void. So such type of agreements from the very beginning, whether it's an agreement in restraint of marriage, agreement in restraint of trade, agreement in restraint of legal proceedings, they are void ab initio, they are void from the beginning. Likewise, a wagering agreement, that is also void. Now, anyone who has an idea about wagering agreement or wager? No. So a wager basically is to do or not to do something which is uncertain. Basically, it's a type of bet. So any agreement where two persons, they enter into a bet, that agreement is void from the very beginning. Like, for example, if two friends, they make a bet that if it rains, tomorrow I will pay you 500 rupees, and if it doesn't, then you pay me 500 rupees. So naturally, one of the persons, they will lose 500, another will gain. So this is called a zero-sum game, where the two persons, one of the two persons, they will lose in this particular agreement. In this, now, any trade, any contract, it should benefit both the parties. And the law states that if any one party benefits at the expense of the other party, it would be a zero-sum game. And such type of agreements, they are void. So any wagering agreement would be void. In any agreement, if one of the party benefits at the expense of the another party, that agreement would be void. So such type of agreements, whether it's a wagering agreement, whether it's a agreement in restraint of trade, agreement in restraint of marriage, agreement in restraint of legal proceedings, all such type of agreements, they are void from the very beginning. So is it clear?
Yes, sir. I have a doubt.
Yes.
Sir, as you talked about agreements that restrain from marriage and trade, I have a doubt regarding government services. Like if you go into army or any defense forces, they ask you to sign an agreement that you will not marry for initially 1 year or training period, whatever is more. And for trade, if you get into any service, then they restrain you from doing any personal business. So isn't that so? That is also an agreement and not declared void.
I'm not aware of this rule in the military that you cannot enter. Of course, during the period when a person is under training, perhaps for that particular period, there may be a bond that may be furnished from that person, probably, but any, I mean, outside that particular, I mean, for the very brief period. Otherwise, if a person is inhibited from marrying someone, actually that would not be valid. Maybe exceptions, like for example in the service, if it's required under the law that in the military organization during the period of training, perhaps the recruits may not marry during that period. There may be that condition, but for all times, I mean, that agreement would not be valid for all times. The other example that you gave relating trade, what was that example?
Sir, if you join a service or work under government, then you are not able to do personal business. Like for other posts, we call it office of profit. You should not be in any trade that you can take advantage of.
There are always there are exceptions to this particular rule. When we come to the topic about the validity of the contract, perhaps we'll take up that in detail. There are many other rules. For example, if you are in service, you cannot enter into any trade with other organizations. Naturally, as employees, for example, we are university employees, university teachers. We cannot take, say, separate agreements with other universities for teaching, even if we are given a larger sum. So there are restrictions, of course, but those restrictions will take up those exceptions to this particular rule in detail in the later slides. But as such, I mean, if we enter into a relation, I mean, into a trade relation, and there are other exceptions as well. For example, if suppose there's a partnership business, and there are 3 partners to the partnership business. One of the partner wants to leave that business, and the partner who has full information about the ins and outs of that particular business leaves that partnership to start a new business. So sometimes there's an agreement in the partnership business, or there's a clause in the partnership business that if you leave this partnership business, you cannot start your own venture in this particular geographical location. For example, if there's a partnership business in Aligarh and one of the partners leaves that business, he cannot start a new business in Aligarh for a particular period of time. So sometimes there are exceptions. We'll take up those exceptions in detail. Likewise, there are exceptions relating to, say, intellectual properties or goodwill of the company. For example, goodwill. If suppose, and this is an example, just a hypothetical example, like for example, there's Vikas Sweets, for example, and Vikas Sweets sells his business to some other party. Just suppose. So, and there would be an express, say, declaration which would be made by the erstwhile owner of the Vikas Sweets that he will not start Vikas Sweets in the Aligarh locality again. Otherwise, he will be able to build up his brand again, and naturally the new owner would face problems later on. So sometimes such agreements are there in restraint of trade, and they are taken up as an exception to this particular rule, that for a particular period of time in a geographical location relating to the goodwill of a particular business, if that owner, erstwhile owner, cannot start a new business in that particular geographical location. So we'll take up those examples in later topics. There are exceptions, of course. And one thing I would tell you, that whenever rules are made, there are always exceptions to the rules. Yes, anything else? Is it clear?
Yes, sir.
Okay. So we'll start with a new slide. Now, the kinds of contracts. First, from the point of view of enforceability. First is the valid contract. A valid contract is a contract where all the necessary conditions which relate to enforceability of an agreement, they are present. So all those conditions where an agreement may translate into a contract and it would be enforceable in the court of law, these are the valid contracts. So as we had taken up in the earlier slide, those the various elements of a valid contract. So those elements, they have to be observed. They should be there to make an agreement enforceable. Yes, Mohammad Abuzar and Kashish, please mute your mic. Now, in case, the second is the voidable contract. Voidable contract is a valid contract. Two parties, they sign a contract. Now, one of the parties may have been forced to sign the contract. Like there may be coercion, there may be misrepresentation, there may be fraud, some misrepresentation by the other party of the facts under relating to the object of the contract, or so such type of agreements, such type of contracts, which where a person has been forced to sign the contract, where the person, one of the parties, has been misinformed about the object of the contract, or where the other party has committed a fraud in making basically the other party and misunderstand the terms of the contract. In any of these cases, this particular type of contract, although it is valid, it can become void at the option of the party who has been forced to sign that contract or has been misled by the other party in signing the contract. So suppose someone makes a contract on gunpoint, asking the other party to sign the contract, and the other party then has the option anytime before the before the finalization of the performance of the contract. That means before the final performance, that is paying the price and buying the goods or buying the land or any other such object. So where the other party, the other party has been forced or has been misled into signing that particular contract or entering into that particular contract, the affected party can at any time make a declaration that he had been forced to sign that contract, and that contract will not be valid anymore. It would become void. So this is a voidable contract where it is valid, but later on, at the option of one of the parties to the contract, that means the affected party of the contract, it becomes void. The same is true of persons who are not majors, who are minority of age, for example, less than 18 years of age, and that minor, he makes another party believe that he is a major, and later on it is discovered by the other party that he is a minor. So that particular party has the right to terminate that contract, because that contract with a minor is a void contract, and anytime it can be, it is void. I've been from the very beginning. Although that minor had made that party believe that he's a major, but when it's discovered that he's a minor, then that contract does not remain valid anymore. So under such conditions, the minor will have to give any benefit back to the other party. For example, any advance, if the minor had taken up from the other party, will have to be given back to the other party. And of course, since the minor does have the right of, I mean, under the particular contract, for example, the partnership business or buying the share under the guardianship of another person, the minor can enjoy the benefits under a contract, but has certain rights under the contract, but does not have the obligation under the contract. So that's the reason why any agreement with the minor is void from the very beginning. But if a minor makes the other party believe that he's a major, then the other party can cancel that contract. So a voidable contract can be cancelled anytime by one party at whose option it can be cancelled. That means the affected party who has been made to sign the contract under pressure, under misrepresentation, can at any time cancel that contract. Is it clear? Now there are four circumstances under which this contract can become voidable. For example, just one I just explained, that if a person is made to sign a contract under pressure, at gunpoint, or has been misled by the other party into signing the contract, at any time he has the option to declare the contract avoided or terminate the contract. So the voidable contract will become void. Other circumstances are where, for example, there is a supervening impossibility. That means, like for example, a contract where would become voidable at the option of one of the parties when he would declare that contract. We will come to another example. That's supervening, basically the impossibility. It relates to how voidable contracts become void. So a valid contract becomes void. So this is another point. Void contracts basically, they are not void from the very beginning. If it's void, it cannot be a contract. So there can be a void agreement, but not a void contract. So void contracts, they are not void from the very beginning, but there may be any circumstance that may come up, any eventuality that may arise, which makes a valid contract void. And as I said, that supervening impossibility may happen in case of a void valid agreement, valid contract. Like for example, if two parties, suppose they enter into valid contract for the sale of a vehicle, for example. Like there's a street where there's an office on the first floor, and two parties, they sign a contract for the buying and selling of a car that is parked outside in the street. And at the time of signing that contract, where all the terms and conditions, they are agreed between the two parties, for example, the price of the car, when the delivery would be made, and all such terms, and how registration is to be done. All such conditions, they are agreed between the two parties, and they sign the contract, unaware of the fact that downstairs some miscreants, they have burnt that car. For example, they had damaged the car and burnt that car. So they are not aware of that. Although it's a valid contract where the two parties, they are unaware of the say damage or destruction of the car for which the sale is made. So this valid contract would become void when it would be discovered that the contract that they had signed, the objects or subject matter of that contract has been destroyed by some miscreants. So a valid contract would become void. Likewise, in case of voidable contract, at the option of one of the parties, a valid contract which has been signed or made, another party has been made to sign under force or by misrepresentation, at any point of time, that valid contract would become void at the option of that particular party. So this is second condition where the valid contract would become void. So at the beginning, it's a valid contract, and if suppose in case that particular party who has been forced to sign the contract under pressure, if he does not exercise the option of terminating that contract, then that contract would remain valid for all times, and that contract would be discharged through performance. So valid contract, it would remain a valid contract unless that option is exercised by the party at whose option the contract would become void. Now, less than 1 minute is left. Can we, do we have another class after this?
Yes, sir.
Okay. So less than 1 minute, we'll again take up this void contract in detail in tomorrow's session, inshallah. So we'll close this session because less than 1 minute is left. So perhaps we'll start again with this third point of void contract.